Okay, we're live.
Great. Good morning, everyone. Good morning.
Morning.
Good morning. The meeting of the Rhode Island Ethics Commission for Tuesday, April 9th, 2024 will come to order. The first order of business is, the first item on the agenda is a motion to approve the minutes of the open session held on March 26, 2024. So, second. Moved by Commissioner Jones, seconded by Commissioner Susie. Roll call vote. Commissioner Jones.
Aye.
Commissioner Strauss.
Aye.
Commissioner Centerini.
Aye.
Commissioner Ritchie.
Aye.
Commissioner Susie.
Aye.
Commissioner Peterson.
Aye.
And the chair votes aye. Okay, the next item is director report.
Thank you. Good morning. Just reminding everyone that we're live streaming our open session meeting today. If you are in the audience on the live stream and you'd like to look at any of the meeting materials, including the agendas or the draft advisory opinions, they're available on our website. So if you go to our website at the bottom right of the page, you'll find a link to meeting materials. The live stream will continue through the open session. We'll close the live stream during executive session today. And then when executive session is over, we come back into open session. The same link that you're on now will reopen to finish the meeting. The chair will report out any actions taken in executive session, and will also post a written report of actions taken in executive session on the website, right next to where you find the meeting materials. Turning to the director's report regarding complaints and investigations, we currently have 7 pending complaints. That's 3 more than we had at the last meeting. 2 of those new ones are on today for initial determination, and a 3rd one will be before you at the next meeting for initial determination. We are issuing the decision in the Richard Nassani complaint that the commission handled 2 meetings ago, and that'll issue today. Regarding advisory opinions, we have 5 pending advisory opinions. 3 of them are on today's agenda. We're doing well to stay up here and current with advisory opinions. The wait is very short and has been for a while, so that's good. APRA requests, we had a lot since the last meeting, I think because the last meeting had a lot of interesting matters on it. So we had 17 APRA requests since the last meeting. We fulfilled all of them within 1 business day. And of those, 15 related to complaints that were on for that meeting, 1 related to recusal and 1 related to financial disclosure. Then just briefly on financial disclosure. Again, as you all know, it's filing month for the 2023 financial disclosure. Statements are due on April 26th of this year. If any of you have any questions about filing or need any assistance, or if you need an extension of time to file, just contact our office, remembering that to get an extension, you have to let us know before the deadline. So extensions have to be requested before April 26th. As of this morning, there are 2,230 filings that we've processed. That's about 54%. And again, that's right where we normally would be for this time of year. That's all I have today for the director's report. So unless you have any questions.
Great. Next item is advisory opinions. I understand there are enough signings, so. First one is Brianna Dixon. Good morning.
Good morning, everyone. Ms. Dixon sends her apologies. She has a training this morning. She did say that she received and reviewed the advisory opinion draft, that she was pleased with it, and that we were fine to proceed in her absence. The petitioner is a social caseworker with DCYF. She started that job last December. Her duties are described on page 1 of the draft, but in a nutshell, she works to keep families together by helping them get the services that they need. She's asked whether she may accept secondary employment as a clinician with the Inner You Counseling Center, which is a private entity where she would provide therapeutic services to adolescents. The reason the petitioner seeks to accept this particular position is because she is currently a licensed clinical social worker who is pursuing the next level of licensing as a licensed independent clinical social worker. These are the 2 levels of licensing for social workers in Rhode Island. In order to become an LICSW, Ms. Dixon must first complete 3,000 hours of clinical work under the supervision of an LICSW in Rhode Island. Now, she's almost there, but she has to complete the remaining hours within the next 24 months or so. The fee-for-service position, which she has been offered with InterU, would allow her to complete the clinical hours necessary to become an LICSW. InterU is not currently under contract to provide vendor services to DCYF. There are a number of code provisions that apply here. First, the petitioner may not take official action in her role at DCYF that would financially impact InterU, nor can she use her position with DCYF or confidential information received through it to obtain financial gain for InterU. That would be 5D. The first I mentioned was 5A. She may not accept other employment which will either impair her independence of judgment as to her official duties at DCYF or require or induce her to disclose confidential government information acquired by her during the course of and by reason of those duties. There's section 5B of the code on secondary employment. Several factors are considered when it comes to potential conflicts of interest regarding secondary employment. These have been incorporated into the analysis that will follow shortly. Finally, pursuant to section 5E under the code, the petitioner may not represent herself or another person, that would include InterU counseling services, or act as an expert before DCYF. Realistically, it's practically necessary that the petitioner pursue her LICSW licensing, doing clinical work, which is very similar to the work that she does at DCYF. Although it could take some conscientious navigation on her part, it is possible that the petitioner could remain in compliance with the Code of Ethics as she pursues her LICSW licensing at InterU. She states that she would complete her work for InterU outside of her normal working hours and without the use of public resources. She adds that she will keep confidential all information acquired during both her public service and her private work. Petitioner also states that during an InterU initial intake interview for a new client in which she would not participate, a new client would be asked whether they're currently open to services with DCYF or had previous involvement with DCYF. And if the client were to answer in the affirmative, the client would not be assigned to the petitioner for counseling services. This would all avoid potential conflicts under sections 5B and 5E. In the event one of her InterU clients were to become open to DCYF during the course of their treatment with the petitioner, the client would immediately be assigned to a different clinician at InterU. Petitioner states that she would then inform her DCYF supervisor of a conflict on the petitioner's part with regard to the assignment of her former client from InterU to her caseload at DCYF. So doing these things would also help avoid conflicts under sections 5B and 5E. I mentioned earlier that InterU is not a DCYF vendor. The petitioner states that InterU might, however, appear on a list of providers that she distributes to clients in need of mental health services in her role as a DCYF social caseworker. Importantly, it would be the client who selects a provider from that list without input from the petitioner, thereby avoiding any potential conflicts under sections 5A, 5D, and 5B. There are several advisory opinions cited in the draft in which the facts were somewhat analogous to those of this matter, and in which those petitioners were permitted to pursue the secondary employment that they desired. Those advisory opinions were instrumental in setting out the conditions under which Ms. Dixon may do so. It is the opinion of staff that the petitioner is not prohibited from accepting secondary employment as a fee-for-service clinician at InterU, consistent with her representations set forth in the draft and provided the conditions that are outlined in the draft. She may not use her public employment to advertise or promote her private work or to recruit or obtain clients for InterU. She may not appear before DCYF in her capacity as a clinician for InterU. There are examples of that on pages 4 and 5. And lastly, the petitioner must recuse from all DCYF matters in which InterU or its authorized representative appears or presents evidence or arguments, and from all matters that will directly financially impact InterU. And of course, this advisory opinion cannot anticipate every possible situation in which a conflict of interest might arise, although we did hit a number of them. It provides general guidance as to the application of the code based upon the facts as represented, and Ms. Dixon has been encouraged to seek additional advice from the Ethics Commission in the future as more specific questions might arise. I'm happy to answer any questions you might have.
Question, I guess.
Yes.
I don't really understand the inclusion of footnote 2,
Footnote 2.
a suggestion about how they ought to do their business.
I will tell you that the suggestion for footnote 2 was adopted from a former advisory opinion upon which I relied. And it was a footnote because I didn't feel strongly enough about incorporating it into the recommendation, but it was kind of maybe a, let's not reinvent the wheel or look how someone else handled it. Because, and the petitioner and I spoke about this, you know, she's the one with the potential conflict here. And so if one of her adolescent clients with whom a clinician builds a relationship should, you know, all of a sudden be precluded from continuing with that client or therapist because of the therapist conflict, might be something that the patient, if you will, or client and their parent or guardian might want to consider before engaging in that. So it's kind of a, it's there, but it's not, you have to do this.
But the representation of fact is that she's not gonna participate in the initial inquiry. And that if they determine that they're open, if I understood the facts right, if they determine they're open to services, DCY services, then it doesn't get assigned to her anyway. So what is it we're suggesting? I think we're suggesting something to the business, not to her, about how they should do those interviews. It just doesn't seem to be, to me, within the advisory world that we're in. And that's why I'm kind of curious about that footnote.
I understand, and some of the, you know, this isn't all in there, but InterU is waiting for her to get an advisory opinion. InterU is aware that she's seeking an advisory opinion. And yes, absolutely, if one of her clients from InterU were to open to services at DCYF, she's off the list of potential social workers assigned. But if she is, if she's treating someone at InterU and, you know, say the child's at risk, many adolescents that require counseling are potentially open, it's just an opportunity to say, you know, she works for DCYF, and if there were a conflict, you'd need a new therapist, do you wish to proceed? It's just, again, I adopted it from a previous advisory opinion upon which I relied.
Many years ago, I worked with then Child Welfare. I was a supervisor with them. What I can see though, as a potential benefit of this is really sometimes when there's a parent of a child and the child may need some therapeutic services. The parent may have some reservations about dealing with a therapist who is involved separately with DCYF, because the parent may have reservations, although there are assurances that certain information may not pass along to DCYF. I think it's just a notice provision out of an abundance of caution that the parent be aware that the therapist has a relationship with DCYF, because at times DCYF and the parent, although DCYF is supposed to help with reunification, there's an adversary relationship in some ways. Well, that's one benefit I could see.
I generally am apprehensive of us going beyond our own jurisdiction or.
Sure, and I just wanted to
I'm not-
mention from where it came, it was, I'm sorry.
I was gonna say, in this case, it's only suggestion, correct? There's no weight to this at all.
Of course, and I just wanted to let you know from where it came. It was advisory opinion 2014-6 issued to Jessica Bonanno, who was a licensed social worker. And she worked for DCY, the Department of Corrections under DCYF, where, bless you, let's see. She wasn't prohibited from providing counseling services in her private capacity at Counseling Services of Rhode Island based on her representations. She worked at the training school, and it was just a similar situation where in here, in the body of the advisory opinion, it said, she states that before accepting a male or female juvenile client not affiliated with DCYF's Division of Juvenile Corrections or Probation, she informs the client and their parent or guardian of her position at the training school. She also advises each client during the intake that should they become incarcerated, she would have to withdraw from their treatment and gives them the opportunity to request another counselor before commencing treatment.
That's different though, because that's on the responsibility of the individual seeking the advisory opinion. This is suggesting that the organization be responsible. Is that not right?
This,
It's just that the client be,
by whom?
By whom, yeah. Yeah, I understand.
That's,
It's usually, oh, sorry. I just wanted to say that when I saw footnote 2, I was actually really happy to read that. I have a master's in counseling psychology, and I know that, first of all, we have a terrible shortage of mental health counselors in the state, particularly for children and teens. It's really difficult. So if I were a parent, I would want to know that up front, because if you've already had a child that's already gone through 2 or 3 counselors, it's so disruptive. It can be so damaging to kids. That I would, if there was any chance that my child would need to switch counselors, I would say, no, I can't have this happen again. Or sometimes they just develop such a caring relationship that it would be devastating to a child or a teen to have to find another counselor. So if it's only a suggestion, no harm, no foul. And it's a really good practice. And there's usually an intake person who's trained to do that for the intake for new clients. So I see it as.
I mean, I don't think anybody's
proactive.
questioning the value of the practice, or if for those of you who know it, that makes sense. For those of us who
Right.
don't, we're apprehensive to actually make suggestions. So I totally understand the precedent-setting nature of.
by way of full disclosure, immediately prior to accepting this job, I was a guardian ad litem for the family court, for DCYF, children open to DCYF.
I make a suggestion.
Yeah.
What if we modify the footnote to say that, the ethics commission suggests that, the petitioner inform the client and put the onus on the petitioner rather than, because it's stated in the passive voice, right? It says the ethics commission suggests that, I guess the client be informed, but it doesn't.
How about by the petitioner of the.
Right,
petitioner's
we could
employer?
suggest that the petitioner disclose, no?
But then it's true,
That's already-
they don't see their patients.
Yeah,
They
that's what I
don't
was
see their
thinking. I don't know
clients.
that that's practical.
That's
That's
already
already
Lauren's
in
point.
Yeah, that is in
It's
the
already in
opinion. But is it unnecessary?
right, I was not really asking to strike it yet. I was trying to understand.
No,
that.
I agree with
That's
you.
why I added what I did, because it's.
I love the value that you've added, both of you, from your experience. I don't think that's the question. That's all. So, but I also don't think it causes any issues because it is suggest, it doesn't have any real weight. But it's something to be aware of in the future.
Understood?
The only way it has is for the employer thinking that the ethics commission has told it what to do. That's the way I'm concerned. It's a
Suggest.
suggestion.
Yeah.
Again, I'm not moving to strike it from the opinion. I'm bringing it to the
It's good.
staff because I was just
Yeah.
curious about the inclusion.
So when the opinion is finally drafted, is that made clear? This is only a suggestion?
Yeah, it says suggest.
It's strictly, it's
Yeah.
no room for interpretation at
Exactly.
all.
Correct.
And suggestion has, the full weight of the findings of this commission. Can that be challenged, the word suggestion? Has it ever been challenged?
Only by my children.
You know, that's another time.
Another
I'm just curious about that. I'm not having this my first time here. So I'm wondering about that. That was a suggestion that when I see it every now and then, I say to myself, suggestion, you know, where is the full weight, the authority of the commission? How does that imparted to the parties?
I don't think suggestion is a mandate. So I think that's the difference.
May versus shall.
Thank you.
All right, are we comfortable moving forward? Any other comments, questions? Is there a motion to accept the staff's recommendation
So maybe.
for a second?
Second.
moved by Commissioner Jones, seconded by Commissioner Peterson. Roll call vote. Commissioner Jones.
Aye.
Commissioner Strauss.
Aye.
Commissioner Centerini.
Aye.
Commissioner Ritchie. Commissioner Susie. Commissioner Peterson.
Aye.
And the chair votes aye. Great, thank you. Next one is Neil Murphy.
Yes, Mr. Murphy apologizes for his absence as well. He is a Block Island resident,
Yeah.
but he stated that he was invited to actually tour the United States Capitol today with the Rhode Island's congressional delegation. And so he's in Washington DC doing that. Mr. Murphy is a member of the New Shoreham Town Council. He's asking whether he may participate in an upcoming vote regarding a proposed ordinance regulating residential short-term rental properties, given that his mother is a short-term rental property owner who would be subject to the ordinance if it passes. Mr. Murphy telephoned me last September to inquire about this issue, and during that conversation, it became clear that he did have a potential conflict of interest because he would be taking official action that would directly financially impact a family member. Without a proposed draft of the ordinance available last September, because it hadn't been drafted yet, no analysis could be performed, which might have led to an opinion that the class exception applied to allow the petitioner's participation. Mr. Murphy has recused from taking part in discussions and decision-making about that ordinance since we spoke last September. So now the ordinance has been drafted and he would like to vote on the final version. We already know that his participation in the vote will directly financially impact his mother, so the only way he can participate is if the class exception applies. And for the class exception to apply, the financial impact upon Mr. Murphy's mother would have to be as a member of a class of persons within a group, and she would have to be financially impacted to no greater extent than any other member of that group. To determine whether the class exception should apply here, we consider the following. A description of the class, that would be all residential short-term property owners in New Shoreham. The size of the class, which is estimated to be 1,000. The official action being contemplated by the petitioner, which is the participation in the discussion and vote on an ordinance which would impose a flat registration fee of $250 for all short-term rental property owners, and the establishment of a way to make sure that all of those rental property owners are paying the already established 1% mandatory annual rental tax. And finally, the nature and degree of foreseeable impact upon the class and its individual members as a result of the official action, which would be the requirement that all short-term rental property owners adhere to the provisions of the ordinance, which are the same for everyone. In other words, the ordinance will impact Mr. Murphy's mother to no greater extent than any other individual who owns a residential short-term rental property in New Shoreham. Accordingly, it is the opinion of staff that the specific facts of this case justify the application of the class exception set forth in section 3614(7)B, and that the petitioner may participate in the discussions and vote on the ordinance. Importantly, the petitioner represents that when the ordinance comes before the town council, it will be just a vote of yes or no. Were that not the case, and/or should the town council's discussions veer into revision of the ordinance in ways that would impact his mother individually, or as a member of a much smaller class or subclass of residential short-term property owners, the petitioner would have to either recuse from participation or seek additional guidance from the Ethics Commission. I'm happy to answer any questions.
That's what you do.
Yes.
Wow.
What a surprise.
I actually am surprises me, so,
Well,
but I'm
yeah,
curious.
except that. Does the current ordinance exclude bed and breakfasts, or is that a pre-existing ordinance?
Oh, it does not include, the petitioner owns a bed and breakfast.
I understand that.
Right,
Does the current ordinance that's being proposed exclude the inns, or is that a pre-existing ordinance? Will this ordinance bring him outside the ordinance itself for his private business?
This ordinance does not regulate inns, the inn that he owns, at all. They have their separate ordinances.
That's what I'm trying to get at, is it's a separate ordinance.
Yes,
Will and this is where I'm not suggesting this should have been investigated, I'm just questioning. So you've got these people with inns, and they're already allowed to do what they're doing. And you have these people with short-term rentals who until now have been allowed to do whatever they're doing. Would not potentially the regulation of the short-term rentals cost them, as a result of which the inn owners will benefit.
I suppose it's possible, but it's certainly not direct. In fact, initially, Mr. Murphy contacted me because someone suggested to him, because he owns an inn,
Yeah.
that he's got a conflict, and that's why he called.
Mm.
And we talked through the fact that it would not include them. And during the conversation, when I realized that they were islanders and his family's from the island, I said, anyone in your family own it? Oh, yeah, my mother. Okay. Now we have a,
And you
now we have
wonder,
an AO.
there's a lot of ends,
So
so would it
the,
affect you more or less than if you have? a-
That's a fair statement.
or the ordinance itself talks about applicability and explicitly excludes the hotels, rooming homes, group homes, et cetera, and it cites to another town zoning ordinance, section 509. I'm assuming that is wherein, I've looked at it, that is wherein like hotels versus short-term rentals defined, but we don't have 509.
And what he's saying is that the impact that this ordinance would have on the short-term rentals that have some kind of effect.
Disparate impact. No, I understand what he's driving at, but the point is that I don't think this was drafted. Or he didn't participate in the drafting of it, so he wasn't at the table saying, actually, can we make sure to exclude inns and beds and
Oh, yeah,
breakfasts? This
yeah,
is
yeah.
what came to
That's a
him,
good point.
and so he didn't, it's an up or down vote either way. It's an up or down vote on his bed and breakfast exclusion, and it's an up and down vote on, or his in exclusion and up and down vote on his mother being included or not. So it seems to me like. the
But do
same
you
effect.
think, do you think that inns would somehow benefit because short-term rentals are being affected? That's kind of the question. Is he gonna have a,
I don't know, but he didn't participate in drafting it, so,
right, but should he not act because it might affect his business as a B and B owner?
I don't know.
Yeah.
I haven't got him all that over. That's not, that seems to be the question
That's
for us.
right. That's right.
You know, the direct financial impact for these property owners is the imposition of the flat tax of $250 for the fee. And then the enforcement of the mandatory 1%, which they've been left to the honor system, I guess. And not ever do. Honoring.
I think there's more than 1,000 houses out there for that, but. You're right.
I think it's the number of,
500 of them.
yeah, it's the number of owners, so maybe some own more than one. But your point's well taken.
Is there a motion to accept the staff's recommendation?
So,
Is there a second? Second, been moved by Commissioner Jones, seconded by Commissioner Susie. Roll call vote, Commissioner Jones.
Aye.
Commissioner Strauss.
Aye.
Commissioner Centerini.
Aye.
Commissioner Ritchie.
Aye.
Commissioner Susie.
Aye.
Commissioner Peterson.
Aye.
And the chair votes aye. Great, thank you. The next one is the Honorable Catherine Kazarian.
Morning,
Good
Commissioners.
morning.
This advice, draft advice is on the top C in binders. Representative Kazarian sends her apologies. She's unable to attend today. She has a prior engagement. However, she's aware that if you have any questions for her that I can answer, you may postpone your decision to for the time when she can be present. Representative Kazarian requests an advisory opinion regarding whether she may participate in House discussions and decision-making relative to a legislation that will prohibit commercial motor trucks with gross weight rating of 26,001 pounds or more from traveling on Route 114A, East Providence, between Pawtucket Avenue and the Massachusetts state line, given that her mother owns and lives in a home along this section of 114A, which is also known as Pleasant Street, and that's how I'll address it. This is the second time the legislation has been introduced. The last time in 2023, that legislation was vetoed by the governor. The legislation is a result of concerns raised by the petitioner's constituents who live along Pleasant Street or the neighboring streets, and the passing of a resolution by the East Providence City Council. Residents are concerned and complain about the large commercial trucks because of the noise, the loud noise they create, the premature deterioration of the roads, and the destruction of the small bridge in the neighborhood. The residents are also concerned about the speeding, the safety of their children while waiting at the bus stop along Pleasant Street, and the safety of drivers who are getting on and off Pleasant Street because of the traffic congestion and the reduced visibility that the large trucks create. The residents have collected more than 100 signatures to support a petition in support of the legislation. The petitioner describes Pleasant Street as a narrow residential road that stretches about a quarter of a mile in length with one lane in each direction. She adds that most of the street has no curb or sidewalk, with the homes being closely abutting that road. The petitioner states that the historic Hunts Mills homestead, which is open to the public, is also located on that street. And also an entrance to a popular reservoir, hiking trail, and dog park that is used by all pedestrians. The petitioner represents that her mother has lived in her home since 1991, and unlike many other neighbors on that same street, she doesn't have a driveway that feeds directly onto Pleasant Street. Her mother also doesn't have school-age children who use the bus stop on Pleasant Street. Her mother has neither signed the petition nor worked with the other neighbors to support the legislation. The petitioner also represents that her mother, neither her mother nor the property will be financially impacted. The petitioner represents it because only the large trucks will be banned, not all commercial trucks. She does not expect that the values of those properties will be affected by the passing of that legislation. In order to determine whether the conflicts of interest provisions of the Code of Ethics are implicated here, the Commission first has to determine whether or not there will be a direct financial impact upon the petitioner's mother. If a direct financial impact is not expected, then the conflicts of interest provisions are not triggered, and the petitioner may participate in the discussion and voting on that legislation. Here, the petitioner represents that her participation in House discussion and voting on the proposed legislation will have no direct financial impact on her mother or the mother's property. Specifically, she states that banning only on the large commercial trucks is not expected to directly financially impact the property by raising the value of the property. Also, based on the petitioner's representation as to the safety concern, there is no indication that the petitioner's mother would be impacted more directly or differently than any of the other residents or visitors who use the road for travel or recreation. Accordingly, based on the petitioner's representations, the prior advisory opinions issued, it is the opinion of the staff that the petitioner will not be prohibited from participating in House discussion and decision making on this legislation. I'm happy to answer any questions you may have.
You know why she asked for it this year and not last year?
I think somebody had raised it as an issue and concern, so she I don't believe she thought of it.
Yeah.
That she would have, that there would be any
Right.
impact or she would have any conflict, and it's been raised as an issue, so she came to ask us for advice.
So if I understand your opinion correctly, it's not based on the class exception, it's based on the no benefit to the mother.
Correct,
So you accepted her representation to that effect, correct?
correct.
Now I ask the broader question. In the past, have we required, in this kind of circumstance, have we required the property owner to get some sort of a professional appraisal or professional opinion on that? Or do we accept the applicant or the applicant's representation that there will not be a financial impact?
So in the recent years, first, the advisory opinions are not investigative, so
Right.
we wouldn't investigate per se on our part. We would rely on their representation. In some advisory opinions, and Jason can elaborate, but I believe sometimes they've given us a report from specialists. However, from a professional, I don't believe that's been like a regular practice for us to require them to give us. If it's a close call, maybe, but, I didn't think it was necessary to require her to.
We've gone both ways.
Yeah, please understand, I'm not suggesting that anybody should have done more or not. I was trying to remember. I remember we had a case involving somebody up in the northern part of the state. There was a development going on, and you may well be right that they presented it. We didn't ask for it. And if that's the case, then I accept what you're saying. I just felt like we'd gotten appraisals in the past. Not appraisals necessarily. Formal appraisals not easy, I'm not saying that at all.
I think that case may have been in the context of a complaint setting. And there was a probable cause here.
Okay.
Joe Penz's client.
Don't remember
Yeah.
that.
I believe in 2014, there was, I believe Jason might have been prosecuting the complaint. It was something similar, and there was a report of a professional, whether or not there would have been a financial.
It's happened in an advisory opinion context also, but even there, sometimes you have to question, is this just a realtor writing a letter with an opinion, or is it a certified appraiser? So we have done both. We certainly have issued advisory opinions in the past where just based on the representations, the commission has said, okay, the facts look like there wouldn't be a financial interest, and there's an affirmative representation that there is not a financial interest. We'll go with that.
And if there is, this opinion's no good. So
Correct. And
if it comes out, then she has to come back again.
correct, the petitioner is aware that this is not investigative. We rely solely on their representation, and it later down the road, it turns out that the representations were not correct, not by fault of the petitioner, then, the advisory opinion is no longer protecting that petitioner.
My question more policy than to this particular case, so
Yeah, thank you.
I appreciate the clarification.
Is there a motion to accept the staff's recommendation?
I so move.
I'll second.
Moved by Commissioner Centarini and seconded by Commissioner Jones. Roll call vote, Commissioner Jones.
Aye.
Commissioner Strauss.
Aye.
Commissioner Centarini.
Aye.
Commissioner Ritchie.
Aye.
Commissioner Susie. Aye. Commissioner Peterson.
Aye.
And the chair votes aye. Thank you.
Thank you.
Okay. Next item is a motion to go into the executive session to take up a motion to approve the minutes of the executive session held on March 26, 2024, pursuant to Rhode Island General Laws 42, 46, 5, 2, and 4, to consider in re Michael Palisante, complaint number 2023-10, pursuant to Rhode Island General Laws 42, 46, 5, A and 2, 3, and 4. In re Michael Palisante, complaint number 2023-12. General Laws 42, 46, 5, A, 2, and 4, and also to consider in re Joseph A. DiMartino, complaint number 2024-5, pursuant to Rhode Island General Laws 42, 46, 5, A, 2, and 4, and to take up in re Robert Mancini, complaint number 2024-4, pursuant to Rhode Island General Laws 42, 46, 5, A, 2, and 4, and then to return to open session. Is there a motion?
Moved.
Is there a second? Second. Moved by Commissioner Jones, seconded by Commissioner Susie. Roll call vote, Commissioner Jones,
Aye.
Commissioner Strauss.
Aye.
Commissioner Centarini.
Aye.
Commissioner Ritchie. Commissioner Susie. Aye. Commissioner Peterson.
Aye.
And the chair votes aye. Great. So we're in, clear.
Great. The live stream will end while the commission is in executive session, and then when they come back into open session, the live stream will begin again.